Buenos días a todos.
Good morning. Now, Isags, the South American Institute of Health and Innovation, which is the strategic center of Unasur institution, will start the streaming of the opening session of this Public Health, Innovation and Intellectual Property, Unasur Perspectives. This will be the first presentation will be delivered by George Washington University Professor Susan Sell. This activity is held in the city of Buenos Aires, Argentina, supported by the National Health Ministry and the group of the Unasur Medicine Access Organization. The conference will be in English with simultaneous interpretation into Spanish and Portuguese. In order to choose your language, please click on the link on the streaming window in the innovacionsalud.isags-unasur.org website. Susan Sell will be discussing the crisis of innovation in health. Then we will have a debate with the audience that gathers experts in the area and representatives of the Ministry of Health and Science and Technology of the 12 countries member of Unasur, and also from people watching us online. Please send your question through the email comunicacao@isags-unasur.org or through Twitter @ISAG-UNASUR and through Facebook isags.unasur-salud. This is the sixth time that Isags disseminates knowledge and discusses significant topics online. This tool strengthens the Institute mission, that is to foster exchange, critical discussion, management of knowledge, and the fostering of innovation in the field of policies and health governance. We would like to thank everyone and every organization that supported us in the dissemination of this conference. The pro tempore presidents of Suriname, the OPS, the Horas CONU, OTCA, CARICOM, the Ministry of Health of Argentina, the Mercosur Observatory, ALAMES, CEBES, the School of Public Health of Osvaldo Cruz Foundation, the Saúde Canal, the Polytechnic School of Health of Fiocruz, the Research in Primary Health Care Network, the Collaboration Network of Primary Health Care of OPS, the region and networks Camino de la Universalización in Health in Brazil, and the SUS network. We are a very young institution, only 3 years in July this year, but Isags has been performing its three basic functions: management and production of knowledge, development of leadership, and technical advisory through certain actions that are prioritized by the Health Council of Unasur. In these 3 years, there have been 14 workshops. We have published 2 books, and we are just finishing the 3rd book to be issued at the beginning of next year. This conference opens the work for the Intellectual Public Health Innovation and Intellectual Property Seminar. That seminar is a main initiative of the annual plan, 2014 annual plan of Isags, and acknowledges the strategic significance that IP has for South America, besides its impact on public health care, innovation, and economic development. The seminar that starts today and ends tomorrow is aimed at discussing some of the big issues related to the correlation between access to health and IP rights, especially that relative to public health and innovation, and the problems with medicines prices that are linked to access and equity. We believe it is essential to discuss the reality of the patent rights in pharmaceutical fields and the significance of flexibility in international law of intellectual property, such as compulsory permits and prior acceptance. The WHO considers that 1/3 of the world population has no access to medicines and vaccines, and it believes that 10 million lives can be saved if those medicines would be available. This reality is so unequal that has triggered debates on commercial agreements in health in recent years, especially after the TRIPS agreement. The TRIPS agreement has created a new global regime of patent protections and have increased medicine prices and has therefore reduced access to medicine, especially in developing countries. It is clear that there is a paradox between trade and health policies. Therefore, it is essential to discuss the international scenario to make decisions on health policies that refer to universal health systems. The protection of patents directly affects medicines prices, which compromises access to medicines. Susan Sell is an expert on the field. She has published 3 books and dozens of articles about intellectual property. She was an advisor of the WHO, of the UN CSTD, of the Ford Foundation, of the Open Society Institute, too. She is also part of the IP Watch Council, which is an independent observatory that disseminates news about the development and execution of international policies on intellectual property. I invite Susan Sell to take the floor to start her presentation. And I wish you all success in your debates. Susan Sell, please.
I first want to thank the organizers for inviting me to be here. It's such an honor and such a privilege for me, and I look forward to learning so much from all of you in the next days ahead. So thank you very much. Before I get started, I just want to say that in intellectual property policy, words matter. Words matter a lot. If we think of the term intellectual property rights, we need to take that apart. Intellectual property rights are not rights. They're not natural rights. They're not human rights. Intellectual property is not real property. It is not like a hammer. What intellectual property rights really are temporary monopoly privileges that are granted by the state to serve public policy goals. In other words, intellectual property rights are a socially constructed scarcity of something that is not scarce. If I have a hammer, that's real property. If you want to use the hammer, we can't use it at the same time. The same thing is not true of intellectual property. So I think the way we talk about it is problematic, and I'm going to use it because that's what everyone uses, but they're not rights, and it's not property. So I want to keep that very clear. I think words actually matter a great deal. These are the topics I'm going to cover today. Intellectual property as a public policy, horizontal forum shifting, vertical forum shifting, the looming threats for public health that are on the horizon. If any of you are fans of the program Game of Thrones, I often feel that the message of my talks is winter is coming. So that's what I'm here to tell you and what to look out for. And then I want to talk about some options for dealing with this in light of this larger political dynamic. So I'll start with intellectual property as public policy. There have been historically shifting conceptions of what constitutes ownership, what constitutes authorship, and what constitutes invention. Again, I mentioned that these are temporary monopoly privileges that the state grants in order to serve public policy goals. In the United Kingdom, the early letters of patent did not reward the inventor. What they did is reward whoever brought the invention over to the kingdom. So if you were a glass blower from Venice and you had nothing to do with inventing glass blowing, you would be rewarded a patent for bringing that technology over to England. The same was true of salt makers. And so I think it's important to understand the origins of this. You weren't rewarding the inventive genius or the invention. It was bringing the technology over. It was the transfer of technology that was being rewarded and not invention. Again, I mentioned these are temporary monopoly privileges. And depending on the stages of economic development that a country is facing, counterfeiting, for example, could be considered to be theft, as it is in the United States, or it could be considered as an important tool of social policy in the public interest. So again, those words, piracy, theft, they are very loaded words, and they don't accurately capture the dynamics behind the public policy logic of intellectual property policies. In general, technology importers tend to benefit from more lax standards. Exporters benefit from more stringent standards of property protection. Now, there are many legal and social benefits of what we call intellectual property. Intellectual property can promote innovation by giving the inventor or the innovator a temporary monopoly and the exclusive right to use or capitalize from that monopoly. It can also, other social benefits of IP, intellectual property, are the dissemination of knowledge. It's a bargain, a public policy bargain. We'll give you a temporary monopoly in exchange for your disseminating this and getting it out into the public domain. So in the past, public policy goals of intellectual property were to attract and retain skilled artisans to your territory. It was to develop agriculture. In the days today of Monsanto, it's hard to imagine, but in the United States, land grant universities, like the University of Minnesota, where I'm from, they were set up to distribute seeds, to give seeds away for free, because one of the public policy goals in the United States at that time was to get people to move westward and to start developing the land and creating arable land to feed a growing population and encourage westward movement. So the land-grant universities were founded to give seeds away. Very different today when the universities have patents on these things. So that's an interesting historical fact about the United States. In addition, a public policy goal of the United States was to encourage literacy. The Puritans all had the Bible, but over time we wanted people to be reading a variety of things. We wanted the creation of an indigenous American literature and cultural tradition. So the United States refused to honor the copyrights or the rights of any foreign authors. And Charles Dickens was particularly upset by this. But what the United States did by not honoring Charles Dickens' rights in his creations was crank out for 2 pennies a manuscript. They would just copy his books to make sure that they were very cheap and available and to get the American public reading and starting to create their own cultural and literature traditions. So we did not, we had a public policy goal of encouraging literacy, so we did not recognize foreign copyright. Other public policy goals of intellectual property policies are to provide jobs, they are to promote public health, which everyone in this room is concerned about, and also to promote innovation through access. Now, when I mentioned that there's a public policy balance between promoting innovation on the one hand and disseminating it on the other, that balance has been lost. That's what I argue, and we have gone astray. And the original purpose of intellectual property protection has lost the public dimension. And I'll talk about that more today. So the question is, why did that happen? How did we lose our way? How did the public policy balance get lost? And I argue we have to say who's making intellectual property policy. And in the United States, domestic private power captured the US policymaking process. So in the 1970s and 1980s, these were the actors who were making intellectual property policy in the United States. These were some of the very influential actors who were more interested in the private benefits that they could get from intellectual property protection rather than the public balance of dissemination. So these US intellectual property-based businesses were concerned about protecting their property rights abroad, just like Charles Dickens had been with the United States back in the day. And what they did is they redefined intellectual property as a trade issue. And they emphasized the benefits to the Americans as being jobs, competitiveness, and innovation. Now, in political science, we use a concept called collective action. And the idea of collective action is that small groups with large resources and intense concentrated interests, intense interests in this case in maximal intellectual property protection, those are the ones that tend to shape policy. They have more resources, and they have very intense concentrated interest in the outcomes of this policy space. By contrast, large groups, like consumers, are much less likely to mobilize for collective action if the costs of action are high and the benefits are diffuse. So collective action very nicely captures the dynamic within the United States in the 1970s and 1980s, in which domestic private power captured the US policymaking process. So I want to shift now to who are the actors. Now, when I was a child, one of my favorite cartoons was Tom and Jerry. And the reason I use Tom and Jerry, and this is fair use in my country, so I'm not violating a copyright, but the reason I use Tom and Jerry is because week after week, every episode, they just chased each other around. There was no equilibrium. It never stopped. And I think this captures very nicely the dynamism and the constant momentum and the movement and the process of intellectual property policy making. And so these are oversimplifications, but it's a complicated policy space, a complicated story that I want to tell. And so these are going to be our guides through the various iterations of policymaking in this space. So Tom the cat, who's Tom in my story? Tom is industry associations like the Pharmaceutical Manufacturers in the United States, Motion Picture Association of America, multinational enterprises, Disney, Microsoft, you know the rest, Monsanto, the United States Trade Representative's Office, USTR, the OECD, Organization for Economic Cooperation and Development, and the World Intellectual Property Organization, WIPO. So these are who these actors are, these who I'm representing with Tom. And what do these actors want? The goal for Tom is to ration IP, to keep it scarce, to maximize the value extracted from owning that property. So the goal for Tom is to ration IP. What are the characteristics of Tom? What? Well, Tom's larger, stronger, and has more resources. By stronger, I mean better connected politically. So those are the characteristics of Tom, who's pushing for maximalist intellectual property policies globally. Who's the mouse? There's Jerry the mouse. And here, again, oversimplification, but for the purposes of this larger dynamic, the mouse I characterize as including developing countries, including emerging markets, non-governmental organizations such as Knowledge Ecology International, Doctors Without Borders, Health Action International, and then some firms. There's some very powerful firms that represent the Jerry perspective. That would be generic drug manufacturers, not the branded generics, but I mean the generic generics. Computer equipment manufacturers who are interested in custom workstations, so they want interoperability between different software platforms. And lately in IT, information technology firms, such as Google. Their position is shifting, but they've been interested in having more open intellectual property policies. So what's the goal for the mouse? What's Jerry's goal? Jerry's goal is to increase access to intellectual property versus rationing. Jerry wants to increase access. And what are the characteristics of Jerry? Jerry's smaller, Jerry's weaker, and Jerry has fewer resources. Even Google, that has a lot of resources, has only recently begun to play the Washington lobbyist game. They've come to it very late, but they've not been big players until very recently. So these are the characteristics of the mouse. And now I want to talk about what the cats and mice have been up to. Horizontal forum shifting. And here I'm focusing at the multilateral level to show you how this has played out. In the 1980s, during the negotiations over the new international economic order, developing countries in the World Intellectual Property Organization were pushing for rather generous interpretations of the Paris Convention and insisting that the terms of the Paris Convention for the protection of intellectual or industrial property had very generous access provisions in it. During that time, the United States negotiators were not happy with this interpretation, and they decided that they were not going to be able to push back against developing countries because they were outnumbered in World Intellectual Property Organization, and they really didn't have any leverage there. So what Tom did is shift forums horizontally to the General Agreement on Trade and Tariffs in 1986. And the reason for that is because the firms that the US was representing felt that the US firms could get some leverage by using its large market and market access as a carrot and a stick to try to get other countries to protect their intellectual property. And so they moved intellectual property issues horizontally into the trade regime. That was a strategic horizontal forum shift in order to get more leverage for their position. So they were able to link to trade so the US could use market leverage as access. So the unequal private power that you saw with pharma and Bill Gates and this Disney that I showed you before, this unequal domestic private power became unequal public power because the United States had market leverage, it had a lot of economic clout. And so this unequal public power extended this logic to international institutions. So what we ended up in 1994 was the Agreement on Trade-Related Intellectual Property Protection. So the TRIPS agreement in the World Trade Organization in 1994. At the end of the Uruguay round, we had an intellectual property agreement that was binding. It was enforceable. It required states to adopt laws protecting intellectual property. It required states to protect pharmaceutical products for the first time for many, many countries. And the quid pro quo was, if you protect our intellectual property, we will offer you market access in textiles and agriculture. Well, we made good on our promises about textiles, but agriculture is still stuck where it was. They did not come through. But in exchange for protecting IP, we will guarantee you market access for your agricultural products and for textiles. Now, the agreement represented a ceiling for developing countries. For Jerry, this is the most he could possibly handle. Whereas for the intellectual property exporting countries, especially the United States, this was a bare minimum. This was a floor, not a ceiling. And the ongoing bargaining divide that continues to this day is between the ceiling and the floor. And that's what a lot of the conflict is about. So, but Jerry also engaged in horizontal forum shifting. It's not a game that only the strong can play. The weak can play it too. And so with the hideous HIV/AIDS pandemic, people started to be concerned about public health and access to medicines. And during the negotiations of the Uruguay round, nobody was thinking about public health. It wasn't on anyone's radar. How do you connect public health with intellectual property? But the HIV/AIDS crisis showed in spades that that connection could lead to unnecessary death. United States, on the behalf of our firms, sued Nelson Mandela, which public relations disaster. But at any rate, so Jerry went to a multilateral forum where Jerry would find a more sympathetic hearing, and that was the World Health Organization. And in the World Health Assembly in 1999, they adopted a resolution that said nothing in intellectual property protection should interfere with the ability of states to provide for their public health needs. And so Jerry engaged in a horizontal shift by coming up with a resolution in the World Health Organization, the mandate of which is public health, to say it shouldn't, intellectual property rights should not trump public health rights. And Jerry was able to shift this into the forum of the World Trade Organization. And in 2001, the beginning of the Doha round of trade negotiations, the so-called development round, the Doha Declaration on the Agreement on Trade-Related Intellectual Property Rights and Public Health was unanimously adopted. And it really didn't say anything that wasn't already in TRIPS. But Jerry wanted clarification because the United States was engaged in a relentless bullying campaign against Thailand, against South Africa, and they wanted clarification. Is it really okay for us to do this? I think we're allowed to. So they wanted a statement that would be under the umbrella of the World Trade Organization. So with the public health issue being very politically hot and contested, everyone paying attention to it, the United States and its partners were not really satisfied with what they had gotten in TRIPS, in their agreement on trade-related intellectual property rights. Because for them, remember, it was a minimum, it was a floor. So they were looking, where can we get more? We cannot bargain for stricter standards in the World Trade Organization because of this health thing. All eyes are on HIV/AIDS, so we got to go somewhere else. So they engaged, Tom engaged in a horizontal forum shift back to, paragraph 6 amendments. That was another thing Jerry wanted That's the only amendment to the Agreement on Trade-Related Intellectual Property Rights, and it was adopted in 2003, and the idea was to allow for states that can't make their own generic drugs to be able to import them under compulsory license. However, it's only been used once. It's so unwieldy, it's virtually unusable. But at the time, people hailed it as a great victory for medicine, but it's been kind of a bust. So I'll skip quick over that one. So Tom shifts back over to the World Intellectual Property Organization. So I showed World Intellectual Property Organization a little bit of love, after having gone to the trade regime. And so what Tom wanted to do in the World Intellectual Property Organization was to revitalize the Substantive Patent Law Harmonization Treaty. And what that was, their aim behind that was to create TRIPS Plus standards that they would not be able to get in the World Trade Organization because everyone was paying attention to the health question and the access to medicines. So Tom tiptoed back over to WIPO, hoping, World Intellectual Property Organization, hoping that it would be able to get TRIPS Plus norms established in the World Intellectual Property Organization. So they went to a forum they felt was more friendly to their concerns. However, leading developing countries had not been sleeping on this issue, and they had been paying attention. And when the United States and its like-minded partners pushed to revitalize these treaty negotiations, leading developing countries said, we refuse to discuss substantive patent law harmonization treaty unless the World Intellectual Property Organization addresses development issues, because they were finding out that intellectual property was having some profound effects, primarily in the healthcare sector. But they wanted to get, they said, you have to address our concerns. The United States sternly warned the World Intellectual Property Organization not to press too far. They said, you're not a development organization. And what this led to was Jerry insisting on a development agenda within the World Intellectual Property Organization. So it was proposed in 2004, a development agenda. They were not talking about the substantive patent law treaty. They were trying to get a development agenda. It was proposed in 2004 by some leading developing countries, including Egypt, and it was adopted in 2007. So this shows you that even the weaker parties can engage in this horizontal strategic forum shifting to find more congenial atmospheres or better outcomes for what their objectives are. However, this has led to another dynamic, which is vertical forum shifting. And here's where the chase of, you've seen Tom and Jerry chasing each other backwards and forwards horizontally, but now it's led to a vertical chase. So I'm going to talk now about vertical forum shifting. And 2 weeks after the World Intellectual Property Organization adopted the development agenda, which the United States was not at all keen on, the United States Trade Representative's Office, the European Community or European Commission, and Japan's Ministry of Foreign Affairs announced their intention to pursue an international enforcement agreement, an international intellectual property enforcement agreement. Now, vertical forum shifting, Jerry chased Tom out of WIPO, World Intellectual Property Organization, and vertical forum shifting is used by powerful states whose vital interests are at stake and where their position on issues is far different than those of the vast majority of states. And that's what we see with the vertical forum shifting. So here we see Tom engaging in plurilateral negotiations with the Anti-Counterfeiting Trade Agreement and the Trans-Pacific Partnership negotiations. And I'll talk about each of those in turn. Now here's a big picture of all these vertical forum shifts. And Jerry tends to do better, I would say, at the multilateral level. And here I'm just going to use the WIPO, World Intellectual Property Development Agenda as Organization's development agenda as an example. The chase the cat, chase Tom down to the plurilateral level. And at the plurilateral level, we see negotiations on an anti-counterfeiting trade agreement, the Trans-Pacific Partnership, and the Transatlantic Trade and Investment Partnership, thank you, sorry. Thank you. Acronyms will be my downfall, but I live in Washington, D.C., and everything is acronyms there. But the vertical form shifting has gone lower and lower. We have regional, of course, with the North American Free Trade Agreement, Central American Free Trade Agreement, bilateral. We have a lot of European Union economic partnership agreements. United States has multiple free trade agreements. And then unilateral, United States Trade Representatives, Section 301 of the Trade Act, which is a naming and shaming device where every year the United States Trade Representative's Office gathers reports from the pharmaceutical industry, from Walt Disney, from Microsoft, and says, announces which countries are on the naughty list that are violating intellectual property protection. And then unilateral, the Stop Online Piracy Act and the Protect Intellectual Property Act, which I will be talking about also in more detail. But the point is, with vertical forum shifting, it tends to favor the strong. It tends to favor Tom, and that's why Tom likes it. It's more costly for Tom to engage in these kind of agreements, but if Tom can't get what Tom wants, the multilateral level, plurilateral is the next best thing. So I want to talk about anti-counterfeiting trade agreement first. Anti-counterfeiting trade agreement was not a trade agreement. It was an intellectual property agreement. That's all it was about. It was negotiated in utter secrecy, and the agreement was all about digital enforcement, enforcing copyrights in the digital age. At some points, there was talk of pharmaceutical provisions being included in it, such as seizing generic drugs that are being transshipped through third countries. But the anti-counterfeiting trade agreement was really about digital enforcement. And in the United States, with the system with the United States Trade Representative's Office, there are about 600 cleared advisors who have access to all the texts, negotiating text. They have access to, they help shape the texts. But those 600 cleared advisors all represent that same group I showed you in the beginning, the owners of intellectual property. There's no public health cleared advisors. There's no consumer cleared advisors. It's all these ones that are interested in maximal intellectual property protection. So they have the ear of the United States Trade Representative's Office. So anti-counterfeiting trade agreement, it was agreed upon, and hold that thought because it becomes unraveled in a very interesting way. So anti-counterfeiting trade agreement, many countries signed it. They negotiated in utter secrecy. The public wasn't brought in on the terms. There were lots of crazy rumors flying around because it was non-transparent. So what the United States, now we go back to US domestic politics, which is a very interesting story that's related to this big landscape I'm trying to sketch out for you today. The Stop Online Piracy Act and the Protect Intellectual Property Act, these were domestic laws. They were also aimed at getting enforcement in the digital realm. They were domestic laws that were really aimed at foreign pirate websites that host infringing content. So what the idea was, by passing these laws, the United States wanted to be able to block US users from accessing foreign websites that infringe American intellectual property rights. They also wanted to block payment servers like PayPal from processing any payments to those sites, like Pirate Bay, for example. And that was the whole plan here. This is what they wanted to do. Now, in the United States Trade Representative's Office, they are very much captured, I would argue, by lobbyists. Former Senator Christopher Dodd is now chairman and chief executive officer of the Motion Picture Association of America, very well connected. This picture on the left, I think, shows nicely who's making policy in the Capitol, especially when it comes to intellectual property, and who's left out on the bottom there. This is a nice depiction, and there's a very robust revolving door relationship between these firms and U.S. trade representatives. Former U.S. Trade Representative Mickey Cantor is now a lobbyist for the Pharmaceutical Research and Manufacturers Association. Many rotate out of USTR and become head of Microsoft Asia. They get very lucrative, very sweet jobs coming out of that. So there's a very interesting capture dynamic. Also, weirdly, the United States Trade Representative's Office is the only federal agency that is not under the Administrative Procedures Act of all the executive level agencies. And what that means is they are not required to post what we call in the United States notice and comment. If there's going to be a policy change, let's say it's Federal Communications, FCC, if there's going to be a policy change, they have to post that in the Federal Register and allow for a period of notice and comment. So consumers, anyone who has an interest in net neutrality, for example, can make their voices heard. The USTR does not have that. It's the only agency that does not. And it operates in utter secrecy. It's a very, very closed shop. And so Christopher Dodd and all the people with United States Trade Representatives connections expected they were going to get their way. Yeah, Stop Online Piracy Act, we're going to get that passed. Protect Intellectual Property Act, we're going to get that passed, because they get everything they want because they're so connected. And it's such a sweet little symbiotic relationship between USTR and these firms. And they give big campaign donations. They have a ton of lobbyists night and day to U.S. Trade Representatives Office and Congress as well. So you can see that they're very well connected and they always get their way in intellectual property. They have for a long time. So, and again, I said these domestic laws were targeted at foreign websites that host, content that is infringing of U.S.-held copyrights. However, something very interesting happened in this case because it was U.S. domestic politics. It wasn't international trade negotiations that are conducted in utter secrecy that the public does not get access to. This is America. We have a democracy. There is testimony in Congress. You could read the testimony. You could go here. You could weigh in on what you thought were the weaknesses of the laws or the strengths of the laws. And a number of consumer groups and websites and even internationally started to get very concerned, including the late Aaron Swartz, who was a big organizer of the protests against these looming laws that would amount to censorship. You know, we don't want Iran and China to censor the internet, but we're happy to do it for Hollywood. I mean, it's very strange. So there was a lot of upset among the internet community, and all these websites planned to protest the laws. They were on the brink of being passed. Stop Online Piracy Act, Protect Intellectual Property Act. And this is a timeline from January 10th to January 17th of the announcements that each of these very popular websites that get millions of users were going to protest. They would go dark. They were going to shut down their sites in protest. And even Wikipedia went completely dark. So when you would go on to Wikipedia, and believe me, all my students at GW, they do go on to Wikipedia when they have to write a paper. All of a sudden, it was a very palpable illustration of what was at stake with these laws. Imagine a world without free knowledge. And so this was a very effective counter movement, but it was open, it was democratic. We were allowed to know what was going to be in those bills. That's the big difference between this and international trade policy. And then Anonymous was hacking all these websites and putting embarrassing personal information of some of the IP lobbyists on the web. And these masks here are Guy Fawkes masks. And Anonymous chose these because that image is owned by Warner Brothers. And every time they use these masks, they're supposed to pay Warner Brothers a royalty. And so they don't, of course, but that's why they wanted everyone to use the Guy Fawkes mask. And the Congress, after all this protest, quickly backed down. They quickly backed down, and after the protests, and so by late January 2012, the bills were completely dead in the United States. And it's important because these bills were trying to do what ACTA, the Anti-Counterfeiting Trade Agreement, was trying to do. And there's a very interesting thing that followed. The Europeans were looking at this saying, oh my gosh, the United States property rights people didn't get what they want domestically. And it inspired them to also mobilize against anti-counterfeiting trade agreement. So there was a very interesting dynamic going from US domestic politics this way to the plurilateral level to the Anti-Counterfeiting Trade Agreement. So the death of Stop Online Piracy Act and Protect Intellectual Property Act in the United States sparked anti-counterfeiting trade agreement protests throughout Europe. ACTA attacks free speech, stop censorship, sharing does not equal stealing anyway. So this sparked protests abroad, which is a really interesting and new phenomenon in this policy space. And this is just a map of all the protests that were going on in Europe on February 11th. So really right after these bills got killed in the American Congress, this is what you got in Europe. People took to the streets on February 11th, hundreds of thousands protesting the Anti-Counterfeiting Trade Agreement. That Europe had already signed, all these European countries had already signed off on it. And so Poland, Germany, Latvia, Czech Republic, Slovakia, Lithuania, they all reject ACTA. This is the Polish Parliament on January 26th with their Guy Fawkes mask protesting ACTA. And the EU Parliament, European Union Parliament, voted 478 to 39 against the Anti-Counterfeiting Trade Agreement in July 2012. So 22 of the 27 member states who signed off on this in Europe cannot ratify it because the European Parliament voted against it. So what do we take away from this particular story is that grassroots activism, political mobilization, and transnational mobilization can dilute private power domestically and public power internationally to boost global welfare. And that's why I think this is such an important story. Even though it's about copyright, it certainly has applicability to health. So now I'm going to shift to public health and talk about looming threats to public health. And here I would want to highlight the Trans-Pacific Partnership negotiations. Again, negotiated in total secrecy. Only the 600 clear advisors are allowed to see the text. Congress, the American Congress cannot even see the text. They're also being shut out of the process, which is often the case in trade negotiations. Congress is getting more irritated by that, but it's often the case. So Congress is out of the loop. It's just these cleared advisors, and the United States has insisted on total secrecy. Now, there have been some leaks of the text, which is the only reason we know. Thank you, Julian Assange. I know you are a flawed man, but WikiLeaks has allowed us to see some of this text that consumers and public health advocates have been barred from seeing. What we find in the treaty is it is TRIPS Plus, which we'll be talking about more this next 2 days, in terms of having much more stringent standards for intellectual property protection. It's also TRIPS minus, in that the flexibilities are sucked out of it. It's also US minus, in that there are no provisions for things like fair use due process of law, things that we tend to think are fairly important, those are not in the treaty. Now, what I think is very important to keep in mind is the bigger strategy of the United States and the IP maximalists here. The countries that the United States and Europe and their firms are really concerned about, none of them are at the table. The Trans-Pacific Partnership is all about China, India, Brazil, Thailand, Indonesia, South Africa. That's who Argentina, that's who these maximalists are most concerned about. Those are the markets. And they know if those countries were sitting at the table, they wouldn't agree to this stuff. They would not agree to it. And again, it's that ceiling floor battle again. And they would not agree to it. So what they're doing in the strategy, and U.S. Trade Representative's office and people from Pharmaceutical Manufacturing and Research Association have told me that the plan, the hope, is to strategically get Trans-Pacific Partnership and then and all the intellectual property things it wants there, and then the Transatlantic Trade and Investment Partnership. And if they get those things together, that will encompass about 80% of world trade. And therefore, China, India, Brazil, Argentina, Thailand, India will have no choice but to sign up to it, have no choice but to go along. And China is pushing back. When Obama was there recently, China announced its own partnership that cuts the United States out. So there's a very interesting pushback going on outside of the multilateral arena. Very little action is taking place in the traditional international arena, international organizations. The action is going on in these vertical shifts right now. So another factor is with the WikiLeaks leaked intellectual property chapter, it shows that the United States is actually incredibly isolated. And only Japan is really with it on these super maximalist intellectual property laws, which I think is interesting. But what the WikiLeaks intellectual property chapter shows us in broader terms, this is another effort of private domestic actors trying to extend unequal power to plurilateral negotiations, and ultimately with the hopes of roping in the whole world in these norms that it cannot get in an open, deliberative, multilateral space. And I think this captures it very nicely. This is not Jerry, this is Mickey Mouse. He's representing Tom. I know it's a little confusing with the cat and the mouse, but this is another effort of, and we see the actors that are involved here. We've got Disney, Texaco, Apple, that's Mickey's other ear, Merck, Johnson & Johnson, Pfizer. This is what we found out from WikiLeaks. This is what is in that chapter. And they're trying to feed all these countries their medicine, and the eye chart behind there says TPP, shut up and swallow. So I think that's a kind of a good summary of what the game is right now in this space. There are a lot of provisions harmful to public health in TPP. There's patent linkage, extended patent terms, extended data exclusivity periods, creating new rights that aren't even intellectual property rights, expanded and additional data exclusivity for biologics, lower patentability standards to facilitate evergreening or secondary patents. There are also limits on compulsory licensing. There are also limits on parallel importation. There's also some mention of seizures of transshipped generic drugs. But as a citizen, of course, I haven't seen the latest text because I'm not allowed to. But this is what we found from the WikiLeaks chapter. Another set of provisions very harmful to public health that I think everyone, this is one of my winter is coming stories, and I'm sure you're pretty aware of it, but is investor-state dispute settlement. And I want to talk about the Eli Lilly case. Eli Lilly, the drug manufacturer, This case has been going on against the Canadian government for 20 years. And Canada, because it has a national public health system that's about getting access and pro-generic drugs, they have something called post-grant opposition. You can get a patent, you file a patent, you get granted the patent, but after that's granted, somebody can argue that that shouldn't have been granted. It's post-grant opposition. So 2 patents of Eli Lilly's patents were invalidated by the Federal Court of Canada. And post-grant opposition is, of course, an agreement on trade-related intellectual property rights flexibility. So Eli Lilly appealed to the Federal Court of Appeal of Canada and later to the Supreme Court of Canada, and the company lost both appeals. The courts decided that the 2 patents failed to meet the standards of patentability. Now, with investor-state dispute settlement provisions under the North American Free Trade Agreement, Eli Lilly pursued, having gotten shut down by the Supreme Court of Canada, they decided to pursue the investor-state dispute settlement channel under NAFTA, and is asking the Canadian government for $500 million. Now, if successful, because they're claiming that our investor rights, Lilly's investor rights over Canadian patent policies, they're saying our rights have been violated and you need to pay us $500 million. The Canadian taxpayer should pay Eli Lilly $500 million because its public health policies violate Eli Lilly's rights in Canada under the North American Free Trade Agreement. So the investor-state dispute settlement mechanism vastly expands corporate rights to directly challenge government policies. And if successful, Lilly will have found a mechanism to override the Supreme Court of Canada and hold Canadian taxpayers liable for $500 million. The cost to public health could be enormous, and public health care systems. And if this tactic is successful, it will spread to let foreign investors override domestic law everywhere. This case is very important for public health because pharmaceutical industry is watching it. It's the first pharmaceutical case that's been brought under ISDS, Investor-State Dispute Settlement, but they're hoping it's the camel's nose in the tent. And if they win, then they can challenge all public health laws that are under these agreements of ISDS. Now, there's some leaked texts that have come out of Canada, and Canada is now asking, under the Canadian-European Trade Agreement that does have an investor-state dispute settlement provision, they're asking that court decisions and administrative tribunal rulings be carved out of the investor-state dispute settlement treaty provisions. So they want to ring-fence public health. Others want to do the same thing with the environment. There have been a lot of environment investor-state dispute settlement cases as well. There's also rising opposition to investor-state dispute settlement in Europe. I believe just several days ago, the European Commission, I think, was trying to reassure Europeans that they were not going to support investor-state dispute settlement in the Transatlantic Trade and Investment Partnership, but it's a very lively debate in Europe right now, and so that's something I think people need to be watching. Also, you're familiar with the plain packaging cases, I'm sure, for cigarettes, where Philip Morris is suing that their investor rights are being violated because they can't use their trademarks. They have to have plain packaging in Australia and Uruguay. So under this investor-state dispute settlement, corporations can demand taxpayers to compensate them for rules that diminish expected future profit. And the language is so broad. I mean, it's open to abuse, clearly. You can bypass domestic courts. It's decided by a tribunal of 3 private lawyers, which is a new cottage industry. These cases are exploding. There are so many of them now. And there's no right to appeal. Oh, sorry, I want to go back one. This is very interesting. This is opposition levels of countries while negotiating the secret TPP-IP chapter. I know it's a little bit hard to read, but if you look at the top line and you see Canada and go across 1, 2, 3, 4 squares, and the darkest burgundy square for Canada is patents, and that's because of the Eli Lilly case. But this is a very interesting chart mapping where points of disagreement are on all parts of TPP. That was gleaned from the WikiLeaks chapter. The WikiLeaks chapter is really great because it identifies who is arguing for what, and it's really wonderful. You can play all sorts of fun visual games with this, but this is, Michael Geist did this. But you can see that Eli Lilly case is reverberating with the Canadians. Okay, so what are the options? We're facing sort of winter is coming, so what are the options? Carlos Correa's guidelines, I'm sorry he's not here, but for the examination of pharmaceutical patents, developing a public health perspective of January 2007. This is an extremely important paper, as I'm sure you all know, but the reason I wanted to put it on a slide is I was talking with one of the cleared advisors for the pharmaceutical industry, and I asked him, what's the most dangerous threat to your program going forward? And he said, this paper. So I thought it was important to highlight it because that's what they're fighting everywhere. You know, if countries are following the guidelines there, pharma is pushing back. They're very threatened by this because they're very threatened if many, many countries adopt the guidelines that Correa recommends, the game might be over. So this was the one thing they said, this has got pharma rattled. So there are other kinds of, some options are domestic policies that you can adopt, of course, that would protect public health and safety, the environment and consumers. Importantly, and I don't think this is being done enough, but you could also adopt competition laws to prevent abuses of monopoly power. I think this has not gotten the attention that it deserves, and this could be a very good way to push back. But there's also, as we've seen from the anti-counterfeiting trade agreement, that sometimes political mobilization that we saw with the Stop Online Piracy Act, Protect Intellectual Property Act, Anti-Counterfeiting Trade Agreement Act can help to dilute private power domestically, can help to dilute public power internationally to boost global welfare. And finally, I think it would be interesting for you to know, and so these are just examples, they're trying to use the ACTA mobilization to scuttle the Trans-Pacific Partnership as well. But in the United States, there's a lot of controversy over Trans-Pacific Partnership and secrecy. The process is seen as non-democratic. And one of my heroes, Elizabeth Warren, told the New York Times this year, why are trade deals secret? I've heard people actually say that they have to be secret because if the American people knew what was going on, they would be opposed, like they were in Stop Online Piracy Act and Protect Intellectual Property Act. Also, there's interesting shifts right now. Even though the Republicans won the midterm elections, there are very sharp splits among the Republican Party. There's some pro-business free trade people, but there are a lot of Tea Party Republicans who hate Obama. They want to stop everything he wants to do. They have sometimes a populist message about jobs, and firms are outsourcing jobs too much. And the Democrats don't like Trans-Pacific Partnership if they're concerned about jobs at home after the financial crisis. So they may kill the fast track. They may not give Obama the authority to negotiate Trans-Pacific Partnership. So there's splits across trading partners. There's also splits within the United States that might scuttle this effort right now. Also, I find it very ironic that Obama wants his signature legacy to be the Affordable Care Act for access to medicines and affordable medicines. Yet the foreign economic policy he is pushing by carrying farmers' water in the Trans-Pacific Partnership Agreement has the exact opposite effect, and it will come back to make American consumers pay much more for their health care. So, I think there's a lot of possible splits that could be exploited to dampen enthusiasm for the Trans-Pacific Partnership in the United States. So cats and mice, what are we going to see going forward? Are we going to have continued conflict, which is what we've seen for quite a while? Are we going to see peaceful coexistence, creative engagement, re-engaging, maybe cutting out all this investor-state dispute settlement because it also is hurting countries that pushed for it in the beginning? Or will there be strategic withdrawal? And I think the case of China offering an alternative to Trans-Pacific Partnership is withdrawing from the US-made order and redefining it in a way that might better reflect interests of countries that don't really look like the United States internally, countries that are home to some of the bottom billion. Their policies cannot look the same as ours. It just won't work. The implications for governance, there's this recursive dynamic of very contested policy space across space and across time, where there's a lot of interesting interactions between the domestic level and the multilateral. The problem of enforcement, is the problem really enforcement, or is it a pricing problem? Is it an underserved markets problem? The democratic deficit is quite apparent in US trade policy making and in international trade policy making, and the leaks that we've seen really raise questions about the legitimacy of the process as well. The Congress is starting to pay attention to as well. And I want to thank you for your ears for listening. Thank you.